This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Welcome to the fourth season of Murgitroyd's Innovation Talks podcast. We're delighted you've joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or via @Murgitroyd on Twitter. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's webinar.
Hello, I'm Laurence Chini. I'm Marketing Manager for the UK and Europe at Murgitroyd. I'm delighted to be speaking today with Eleanor Coates. Hello, Eleanor.
Hello there.
Eleanor, you're a Trademark Director in our Glasgow office. You've been our Brexit expert and you've been keeping us in the right tracks since the referendum, really.
Yes, a little bit longer than anticipated.
Excellent. So you've been writing articles for us. We've got a Brexit hub, which can be accessed through murgitroyd.com/Brexit. Today we thought it'd be useful, to do a podcast on the subject of Brexit. So would you like to start with the situation on patents, please?
Well, in terms of seeking protection for patents, there's not really any change at present. However, it was announced last week that the UK will not now participate in the Unified Patent or the Unified Patent Court, despite it ratifying the agreement last year. The Unified Patent System is to establish a unitary patent having effect throughout the EU member states, although the establishment of the system is still in some doubt in any event, as Germany has yet to ratify the agreement.
Yeah, that's really good to know. At least one thing is certain
Yes.
amongst the Brexit debate. What about the situation for trademarks? Is it the same as patents?
No, trademarks differs quite a lot. We have the European Trademark Registration, which covers all 28 member states of the EU at present. Now, obviously, when the UK actually exits the EU on the 31st of December 2020, that is the end of the transition period we're currently in, the UK will no longer be part of those 28 member states, and the EU trademark registration will only cover the remaining 27 member states of the European Union. However, if you do have an existing EU trademark registration, you will still have protection in the UK. The UK government has confirmed it will be issuing out a comparable UK trademark registration, mirroring the details and dates of the EU trademark registration for all holders, and it will be automatic and free.
Oh, free. Excellent. That's
Yes.
great news indeed.
So if you're a holder of an EU trademark registration, you don't have to take any action at present for existing registrations.
Anyone with an application pending, what would be your advice?
Well, if you have an application pending, you will not be given the automatic and free comparable UK registration. You can still request it, but you will have to pay the official fee and it will start the examination process again in the UK as a national UK application. If you are therefore thinking about launching a product really from the latter half of this year, you may want to think about filing both a UK and an EU registration, simply because a UK trademark application filed nationally can take about 3 months to secure registration, so it's a very quick system. Whereas if you're filing an EU application, it can take 6 to 7 months. And therefore you may find that you don't have your registration through before the 31st of December 2020, and then you have to then subsequently apply for this comparable right, paying the extra fee. So
You've got to watch closely all the developments.
I think so. I mean, the UK government can request an extension to this transition period, but they have to file that request for before 1 July 2020, and that will extend the transition period till 31 December 2022.
Really interesting. So any examples of what your current advice
Well,
is to?
we are at the moment saying carry on filing your EU registration at present, but towards, I think, sort of May, June time, if we start to hear about there might be an extension, the situation would remain the same. You would just carry on filing an EU application, then you will get given your UK comparable registration for free, which would be best scenario. But if we are running into that point where the 31st of December 2020 is going to be the final date, and then you are launching a product going to be into the autumn or into the spring of 2021, then you may want to look at filing a UK application at the same time as filing your EU EU trademark, simply so that you have that UK registration in place when you launch.
Sound advice. There was one question that I'm often asked. Is it correct that current UK and European trademark attorneys may lose EU representation rights?
Yes, that is correct. I mean, at present, I am a UK qualified trademark attorney and I am also a European trademark attorney. So I'm a professional representative for the EU IPO. But after the end of the transition period, I will lose my ability to be a representative before the EU IPO. Now, at Murgitroyd, we're in a very fortunate position where we have offices throughout the European Union, in Dublin, Milan, Munich, Nice, Helsinki, and we have attorneys who have been well established there. So we will not have any change to our sort of practice, but other than perhaps the actual person who may undertake the work may differ. However, if you are with a firm who does not have a European office or does not have European attorneys, it is something perhaps to raise with them and query how they will be dealing with that process, if they will be filing direct themselves or whether they are having to use a third party.
Interesting. Thank you, Eleanor. Maybe a good time to mention that we have a specific designated email address for any Brexit-related questions. It's brexit@murgitroyd.com. So please don't hesitate if you have any questions. We've covered patents, we've covered trademarks, designs, anything?
Well, designs are very similar to the trademark position in that if you have an EU design registration, you will be granted the UK comparable registration automatically and free. If you have a design application, an EU design application, you again would have to request a comparable UK design application be created. The difference for designs is that designs are registered very quickly. So generally it's 3 to 4 weeks from the date of filing that you would receive your certificate. The only factor you may want to take into account is if you are thinking of deferring publication. Because if you file a design, firstly it has to be new, but you can request to defer that publication if you want to keep your design sort of under wraps for a little bit longer. And then that sort of can put a halt onto the design registration process. So instead of taking the 3 to 4 weeks, you could defer publication for 6 months. And that could see you in a position where you're having to request the UK comparable design.
Interesting. Well, thank you so much for your time, Eleanor. It's been really interesting to hear, fascinating to hear the latest development. I'm sure you'll be keeping a closer eye on future developments.
Yes, I mean, it certainly is something at present. We're not suggesting that clients have to take any specific action, but it is one to monitor. What we're saying to clients at the moment, and I've been to a lot of clients recently who are routinely asking the question, should I be doing something? And at this stage we're saying, not necessarily, but we need to keep an eye. If you've got new products coming out and you're going to be launching in the autumn, we might have to think of filing them in a different manner to what we would normally do so.
Interesting. So obviously the general advice is always to keep in close touch with your trademark attorney, to keep them aware of anything, any plans, any ideas you have.
Yes, I mean, that would be the case anyway. If you've got a new product coming out, it is always worth getting in contact with your attorney and just sort of seeing what protection is available, when should I be filing it, regardless of Brexit at all.
Indeed. Well, thank you so much, Eleanor, and speak to you soon.
Okay, thank you.
Bye.
Thanks for your time today. We hope you found today's podcast valuable. And don't forget to subscribe to make sure you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.